Hey there, guys. Welcome to the Think Tank. Bright and early, 4 a.m. where I am. I downloaded the paperwork that the prosecution put out in response to that 136-page defense motion. So I thought I better grab it last night because I don't know if this slipped through the cracks like the other one, but I have been waiting for something to come out in response to that. And this is what we have. So this is the state of Indiana versus Richard M. Ellen. So the state's second objection to defendant's motion to suppress. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully objects to the defendant's amended motion to suppress and would ask the court to deny the same in support of said motion, states the following: that on May 19th, 2023, defendant filed a motion to suppress the evidence seized as a result of the search warrant executed on the home of the defendant. That on the day of September 13th, 2023, the defendant filed an amended motion to suppress the evidence seized as a result of a search warrant executed on the home of the defendant. That defendant alleges that the search warrant is unconstitutional because the issuance of the search warrant was a result of an improper ex parte application in the affiant. Sheriff Tony Liggett failed to advise the judge of material faces and made false and misleading representation with reckless disregard for the truth, and that without these false and misleading representations and omissions, the search warrant would not have been issued. This commonly referred to as Franks versus Delaware. Argument from Franks versus Delaware: that per the Franks case, the defense attack must be based on deliberate falsehood or acts of reckless disregard for the truth, and those allegations must be accompanied by an offer of proof. That the claim should point out specifically the portion of the warrant affidavit that is claimed to be false, accompanied by a statement of supporting reasons. That this should be supported by affidavits or sworn statements or other reliable statements from witnesses, or an explanation for their absence. The defense has filed such a memorandum outlining their beliefs of what has been omitted and false. That once again, while the memorandum is colorful, dramatic, and highly unprofessional, it is not completely true. So what do you think of that last little part of this? It is not completely true. Is this telling us that parts of that is true? Let me know what you guys think. That the state believes the allegations outlined by the defense are not supported by evidence that they have collected. That Sheriff Tony Liggett did not intentionally or recklessly omit evidence or lie about evidence in the probable cause affidavit to support that search warrant. So, are they saying that this whole thing is false? Are they saying just what the stuff about Tony Liggett is false? That the defense also alleges that the search warrant was unreasonable under Indiana and federal constitution, in that it lacked probable cause, that it failed to establish that the items to be seized were in the residence or could be explained to be in the residence, that the affidavit failed to provide particular information, that particular items related to the particular crime would be found in the home, and that the affidavit failed to connect generic items to actual items that were possibly used in the crime. So it looks like they're not too frightened of what they had to say. I mean, they're calling it, what? Colorful and unprofessional. So that in September 2022, while reviewing the evidence in the investigation into the deaths of Abigail Williams and Liberty German, investigators discovered an interview that was done with Richard Allen in 2017 by Indiana Conservation Officer Dan Doolin. Dan Doolin. So I think this is the one that happened at the grocery store as one was going in and one was going out. And it was like, hey, I think that was what Richard calls his first statement. So that 2017 interview, Richard Allen admitted being on the trail the day that Abigail Williams and Liberty German went missing. He stated that he was on the trail between 1:30 p.m. and 3:30 p.m. and that while he was on that trail, he was using his phone. That on October 13th, 2022, investigators invited Richard Allen and his wife, Kathy Allen, to speak to them and on a follow-up interview that was done in 2017. That both Richard Allen and Kathy Allen came to the interview on their own on October 13th, 2022. They are not under arrest and were free to leave the interview at any time. That investigators learned from those from those interviews that Richard Allen reaffirmed that he was in fact on the trails the day that Abigail Williams and Liberty German went missing, and further admitted to being on the High Bridge, remembering that that's where he said he was watching the fish jump. So that he also told investigators that he was wearing blue jeans or a black or blue Carhartt jacket with a hood, and that he was wearing a head covering. That further, Richard Allen stated he owns guns and that the guns were in his home. That investigators learned from Kathy and Richard Allen that they still had these guns and knives in the home, along with a blue Carhartt jacket. The investigators believed a firearm was involved in the abduction and the deleting of Abigail Williams and Liberty German. So it was involved in the abduction and okay. So let's see here. That part just kind of made me think a little bit like, what do you mean? And of their deaths. Okay, so it was an unspent .40 caliber round, and it was found between Abby Williams and Libby German. Investigators believe the knife was used in the deaths of Abigail Williams and Liberty German. The clothes that Richard Allen described wearing the day he was on the trails matches the description of the man seen on the bridge from the video taken by Liberty German's phone. That it was also gathered that Richard Allen still possessed the firearms, the knives, and the clothing, and said items were in his house. That based on this information, investigators prepared a probable cause affidavit in which a search warrant for the home of Richard Allen, their probable cause affidavit. The affidavit covers all the information and law enforcement had gathered, all the information that law enforcement had gathered in the investigation in regards to Richard Allen up until October 2022. That the probable cause affidavit outlines evidence that established probable cause to search the home of Richard Allen. So I'm still thinking they must have found something, because why are they trying to get this search thrown out, guys? What do you think? That the investigators applied for the search warrant on October 13th, 2022. The same was granted, and the same was granted that day by Carroll County Circuit Judge Benjamin Diener. Now, I do believe is he the same guy that recused himself? I'll have to double check. So investigators went to the residence of the defendant located at 1967 North Whiteman Drive, Delphi, Indiana, knocked on the door, and executed the warrant on October 13th, 2022. The defendant and his wife were asked to be out of the residence while the search warrant was executed, but were allowed back in the residence immediately afterwards. Investigators found several items in the residence, including a .40 caliber firearm, electronic devices, all of which were outlined in the search warrant return. That for a search warrant to be valid, it must be accompanied by an affidavit that establishes probable cause, which is sufficient basis of fact that exists to permit a reasonably prudent person to believe that the search of the premises will uncover evidence of a crime. The Indiana Code specifies that minimum information necessary to establish probable cause, which is as follows. Information, particularly describing the house or place to be searched and the things to be searched for. Information alleging substantially the offense in relation thereto, and that the affiant believes and has good cause to believe that the things sought are concealed in that place, and they are attempting to search, or the person to be arrested committed the offense described, and information setting forth the facts known to the affiant through personal knowledge or based on hearsay, constituting probable cause. That under the Fourth Amendment in the state's Constitution, the evidence needed to obtain a search warrant need not rise to the statute of facts necessary to obtain a conviction. The circumstances alleged in the affidavit need only lead a person of reasonable caution to believe that a crime has been committed. That when the sufficiency of the search warrant is challenged under the Fourth Amendment by a defendant, as it is in the defendant's motion, the role of the reviewing court is simply to ensure that there was a substantial basis for finding probable cause, reminding itself that it owes great difference to the initial probable cause determination, and will not invalidate a warrant by interpreting probable cause affidavits in a hyper-technical rather than a common sense matter. That under Article 1, Section 11 of the Indiana Constitution, the reasonableness of the search is determined by using the Litchfield test, which looks at the totality of the circumstances and requires consideration of both of the degree of intrusion into the subject's ordinary activities and the basis upon which the officer selected the subject of the search and seizure. That the inquiry requires a balance of degree and concern, suspicion, or knowledge that a violation has occurred, the degree of the intrusion, the method of the search and seizure imposes on civilians' ordinary lives, activities, and the extent of law enforcement needs. That the state believes that the affidavit does meet the threshold to establish probable cause under the Fourth Amendment of the United States Constitution, in that there was a substantial basis for finding probable cause, and there was a high likelihood, based on the evidence the investigators had, that there was evidence of the crime in the home of Richard Allen. That the state believes that the affidavit accompanied with the search warrant for the home of Richard Allen does establish probable cause under Article 1, Section 11 of the Indiana Constitution, and does pass the Litchfield test for reasonableness under the totality of the circumstances. The state believes that the affidavit establishes the items to be seized were in the residence by statements made by Richard Allen and his wife, Kathy Allen. The state believes that the affidavit provides particular information and particular items related to a particular crime will be found in the home based on statements made by Richard Allen and his wife, Kathy Allen. That the state believes that the affidavit connects generic items to actual items that were possibly used in the crime based on the investigators' evidence that they gathered throughout the investigation. That the evidence was gathered in 2017 was reaffirmed by the interview done with Richard Allen and his wife, Kathy Allen, on October 13th, 2022. Investigators believe at the time that they had enough probable cause to apply for the search warrant. Investigators also believe that if they did not execute a search warrant on the residence immediately, that there was a danger that the defendant would destroy crucial evidence in the investigation. The investigators believed through their training and experience that there was a real chance that the defendant would destroy once he knew he was a suspect in the crime. Wherefore, the state has shown that the actions by the officers were valid and justified and did not violate the defendant's Fourth Amendment under United States Constitution, Article 1, Section 11 of the Indiana Constitution, and therefore the motion to suppress should be denied. Respectfully submitted, Nicholas C. McClellan, prosecuting attorney. Signed and delivered. So what do you guys think? Is this going to be enough? Are they going to be able to just, defense just going to be able to shut this down? Or do you think that was a bunch of hogwash and that the judge will see right through it and go along with the prosecution? Well, I guess we're going to have to wait and see. I'm sitting here wondering what that 136 pages was all about still. It is so full of things that we have absolutely never heard that it's almost shocking. So that is out on plenty of different channels. Up until this point, I still have not released the document. I have it all redacted and ready to go for when I do feel comfortable. But right now, there's just too many names on that I'm not comfortable putting it out, even though the names are redacted. I know that some others have put those names out, like I said, and like when I'm feeling a little more comfortable, maybe we will go through it. But for now, friends, thank you ever so much for hanging out with me bright and early. I appreciate you guys. Let me know what you think down below. Don't forget to subscribe, hit that thumb. I appreciate you, and I will see you in the next one. Bye.